This is a story about a case or cases that I worked on in 2013 while I was still a partner at Pepper Hamilton, and involved these two children, Sarah Murnaghan and Javier Acosta. Sarah was 10 at the time and Javier was 11. They were both patients at the Children's Hospital of Philadelphia. Each child suffered from cystic fibrosis. Each needed a new set of lungs to live. As you can see from these photos taken at the time, the children depended on non-invasive ventilation for assistance in breathing. I knew nothing about either child before May the 28th of 2013. That day at 1:57 p.m. I received an email from my law school classmate, friend, and then law firm partner Tom Gallagher. And it said, "Steve, do you have any thoughts/interests? Tom." And below the email was a message from a friend of the Murnaghan family asking our law firm to come to the assistance of the Murnaghans, and in particular 10-year-old daughter Sarah, who was, quotes, losing her battle with cystic fibrosis because of a policy that prohibited her from getting the adult lungs her transplant doctors have approved to save her life. We are looking for a Philadelphia law firm to take the case pro bono. Sarah was weeks away from death. I read an attached article from the Washington Post. I paused for a moment to consider my schedule. I thought of my own children, 9 and 10, and I thought this was a very difficult case. In our letter to the Secretary, we pointed out that it makes no sense for the OPTN to continue to subject children to unfair discrimination, in other words, to have them under a waiting list method, simply because it could not prove that the LAS system worked for children when it developed the system back in 2004. The other main point was the discriminatory effect on children, and I worked on this with Janet Murnaghan's sister, Sharon Ruddock. Janet Murnaghan was not leaving her daughter's side at this particular time. The child was extremely sick, and I needed a witness. I needed somebody from the family to provide me with facts. And she has a sister who's more or less joined at the hip with her named Sharon Ruddock, and so Sharon came down and served as my witness and provided me with all the information I needed. And I also had a quantitative analyst by the name of Arthur Baines, who's with Charles River Associates here in Washington, who I recruited that weekend to come in. We did it by phone, but to help me, and he did that on a pro bono basis, I might add. So we didn't, from a legal perspective, we felt that we did not need to prove a discriminatory effect on children. And this is important because the policy on its face treated children under 12 differently than people 12 and over. So we felt we had a strong argument without statistics. That's a legal argument. And then in the end, we made just a few simple points with the statistics. First, as we said in the letter, it stands to reason that any time a system allocates health resources by segmenting the population based on age, significant disparities could result. In fact, disparities are what you would expect. Close quotes. I'm quoting myself there. Here are the statistics we put forth on this point. In 2011, persons aged 18 to 34 provided 50% of the donated lungs and received 12% of the transplants, while persons aged 65 and over provided 1% of the donated lungs and received 27% of the transplants. So, I mean, I think those numbers suggest that it would be unfair to allocate lungs within the adult patient population based on age, and so too our argument is it's unfair with respect to children. I was really concerned that our client, Sarah, might die at any point, and that I would be, if I didn't move into court quick enough, and that if we didn't move quick enough, we'd look back and we'd say we should have done something faster. So I'm waiting for a response. I have to give the secretary a reasonable amount of time to respond to my letter, at least a day, so she can read it and her advisors and her can talk about it. So I was fidgeting and waiting very nervously, and I was not the only one who was who was nervous. Secretary Sebelius had to appear that Tuesday, June the 4th, before a House subcommittee. And I conferred with our clients, and we decided that if we got any response from the secretary in the morning, other than an immediate agreement that Sarah was going to be treated as if she was 12 or older right away, and that the system was going to be programmed so that she could take advantage of a lung that came into the system that same day. And we got anything less than that, we were going to go into court, that we couldn't afford to do anything else. So, June the 5th was that next day. This was one of the more successful days of my legal career. The previous day ended late, and this day began early. I was at my desk at 7:30 finalizing the orders on the TRO papers. I spoke with the lawyer from HHS at 9:30, and she said there was no answer yet. There might be one soon. I said, thank you very much. We're going to have to go to court right away. We had a litigation team from Pepper Hamilton. I had already signed the complaint. A runner immediately went to the courthouse to file the complaint. Another copy of it was printed out in Washington, D.C., and somebody from Pepper Hamilton's office walked it over and delivered it to HHS. So the agency was formally served within an hour. We sent a subpoena to Dr. Goldfarb, and we told him that we're going to need him in court. I called Arthur Baines, and I told him to get up to D.C. on the train. I told Sharon Ruddock to meet us over at court. I prepared an outline of what I was going to do. It was just really quick, and then I prepared another outline of facts to cover with Dr. Goldfarb. That's it. And then I got a call to come over to the court. So I went over to the courthouse, and the runner was waiting for me in the clerk's office, and he said that they needed you here. I said, fine. He said, the case has been assigned to Judge Michael Bailson. We sat on the bench outside the courtroom, and I was like a caged tiger. I mean, I really was, I couldn't really sit still. And then she came out after a few minutes, and she said, okay, you should go in. The judge was in the middle of a trial. She said, go right in and go right up to the bench. So we walked right through the courtroom. There was a witness on the stand. There was a lawyer at the podium. There were people in the courtroom. And I went up with Eric Rothschild, and I went up and I said, and he looked over at me and said in a stage whisper, what were you waiting outside for? You should have come right in. And I said, Your Honor, we're here to be heard on a matter of life or possibly death involving a child. Ours matter. That got his attention. And he adjourned the trial and had everybody leave, and then he had us come in, and then he had Dr. Goldfarb come. So if you want to hear Dr. Goldfarb's testimony, there's an audio clip on the federal court website, which is also on my website, steveharveylaw.com. It's really fascinating testimony. He testified that Sarah's condition had grown worse, that her medical team was and had been on the verge of a decision about intubation, that decision would set in stage a finite process, and that Sarah had possibly only weeks to live. And he provided lots of interesting testimony about cystic fibrosis and Sarah's condition and lung transplantation. And he testified unequivocally that she would die without a transplant, that her chances of receiving the transplant would be much higher if she was treated as if she were 12 or older. At the time when that happened, I thought to myself, baseball? Did he just say that she would play baseball? And then I later went back and I looked at it. It was almost like a dream, like that had that particular go to camp, play baseball, play with their friends. And I later realized that I was still very, very keyed up trying to win this hearing, but that at that point the equities were rolling pretty heavily in our favor. On the one hand, we had almost certain death for this child. We had a tenuous rationale. And then on the other side of the scale was the prospect that Sarah might run around and play baseball. So that was, I think at that point the hearing was going quite well. And that's what happened. Judge Bailson granted the TRO. He emphasized that it was a TRO and that his ruling on a preliminary injunction could be different. And with that he announced that he would sign the formal order. Less than 30 minutes after the hearing ended, I received an email from Milagros Martinez, the mother of 11-year-old Javier Acosta, another cystic fibrosis patient at CHOP. I showed you his picture. I was really busy right at that moment because I still was trying to get an order entered, and so I responded. I said, I'll be back in touch with you very soon. And we spent the next few hours really ensuring compliance with the judge's order, because I don't have any questions about the good faith of UNOS or to implement the order, but you're going into a bureaucracy. My client needs to be treated as if she's 12 or older right away, so that if a lung came in, she could take advantage of it. And so it wasn't until about 9:30 that night that we got confirmation that the UNET system had been programmed. And so I could breathe a little freer on that. And then I went over to Children's Hospital and I met Milagros, Millie. I didn't meet either child. During the course of this lawsuit. I've since met them. And she told me about Javier. She also had another child, Jovan, who died in 2009 of cystic fibrosis. Cystic fibrosis runs in families. And he had died waiting for a lung at 11 years and 11 months. And at that particular time, Javier was 11 years, 11 months right then. This case stood at the intersection of a lot of different systems, the medical, legal, regulatory, political, and media systems, and they all performed differently. From my perspective, the legal and regulatory system worked well. The secretary made her did what she was going to do. I think she had, a basis. I personally think she was wrong, but there's, reasonable room for disagreement. And there is judicial review for rare cases, and this was a rare case. And I think the judge made the right call based on the possibility of irreparable harm. The medical system, of course, performed beautifully. I mean, this is the wonders of modern medical technology. From the broader medical system, there has been some pushback. There's some criticism of the decision and the ruling in this case. There was an article in the Annals of Internal Medicine that said that the judge valued the lives of these two children as more valuable than others, and I think that misses the point. I don't agree with that. I've already responded to that. More recently, there was two pieces in the Journal of Transplantation saying that our statistics were wrong, they were calculated incorrectly, and that we shouldn't have included children under 5 because there's lots of deaths among children under 5. And we are going to respond to that. There will be a response. They were not calculated incorrectly. They were calculated correctly. As to the children under 5 point, that may be true. That's data we wouldn't know. That's a very interesting. But that also suggests, it really makes this case, it makes a point about our case, that 12 is not the place to draw the line. That, and then there was another piece that said that the lawsuit, that these statistics said that the lawsuit was without merit. And I very much disagree. The system on its face discriminated, so there was no need to prove an adverse effect. And we did prove an adverse effect. Dr. Goldfarb's testimony proved an adverse effect. The media and political systems also responded. The political response was odd. Even though right from the beginning I knew there was an Obamacare angle to this, and I knew that somebody was going to say death panels. And of course Sarah Palin and Rush Limbaugh said death panels, and Lou Barletta. Still, these politicians were on the side of my client, and I thought their underlying position was correct, so I was grateful for the support. And the media did their jobs of getting the story out there. As I said, there was a lot of great coverage from the Times and others, but there was some really bad. My favorite bad reporting is this statement in the Houston Chronicle on July the 16th. It said about the National Organ Transplant Act that former Rep. Al Gore passed the National Transplant Act of 1984. That Al Gore, he was so powerful he could pass a law on his own. How did that get by the editors? But some misinformation is inevitable. And this story did raise awareness of the need for organ donation, and that's a good thing. So thank you for listening to me. I'd be happy to take any questions. Yes, sir.